Hello, and welcome to the Legal Concierge podcast hosted by Warner Lewis. Warner addresses a wide range of questions about legal situations and solutions that may apply to you. The information provided in this podcast is for educational purposes only and is not a substitute for legal, financial, or medical advice of any kind. Warner Lewis is a trusted, reliable resource to help you find the answers you need when you're not sure who to turn to if you have a legal question or need an attorney. Chat with Warner live, every Tuesday on YouTube. And now, here's Warner Lewis.
Hello all. Hi, I'm Warner Lewis. Welcome to this inaugural edition of the Legal Concierge. I'm very excited to be talking with you through this podcast. I'd like to reach a lot of people so that we can accomplish our purpose together, which is really to answer all of your legal questions and to provide solutions for your legal needs. So this is for you, for your particular circumstance, the people that you know and care about, like family, friends, business associates, because our lives involve legal issues from time to time. You know, birth requires a birth certificate, guardianship if something should happen to parents, adoption. I mean, there are all kinds of transitions in life that require legal solutions and legal information. So this is really, I think, an important area of us to be aware of, for us to be aware of and conscious of as we go through life, because you can't really let legal needs or legal questions go unanswered or go unmet, because then they can kind of catch up with us and hit us over the back of the head unawares. Okay, so this is really about understanding the law, how it applies to you and how it can help you if you're able to access the right solutions and the right information, and how it can hurt you if you're in the absence of good information and introductions to competent legal professionals who can help you with your needs. So right now I'm going to get into the habit. I'm going to start with the habit of asking you to take a moment right now and like, share, and subscribe. It's in the information box below this video image. So if you please do that, just like it and subscribe, that would be terrific. That way we can provide you notifications every time a new podcast comes up. Okay, it'll be a pleasure to have you join us, and I really appreciate it. You can also, as you have questions or a particular legal situation that you'd like a little bit more information about, just go ahead and text us. Text us your question, and I'll be able to address them as they're submitted. Okay, terrific. So let me start with giving you a little bit of background about me and why I'm doing this particular podcast at this time in my life and in my career. So 27 years ago, I started my business around estate planning, doing wills, trusts, and powers of attorney. And the reason that I chose this area of the law is because my family went through a circumstance that was disastrous. My father and grandfather both had their wills and trusts prepared by an attorney who was out of state, who did not live, reside, and practice in the estate in which they lived. And so as a result, some things went wrong, and I'll share a few examples of that with you in just a moment. But another sort of more insidious arrangement came up through these documents that my grandfather and father didn't really consider fully, I don't think, and that was say yes to the attorney when he suggested that the attorney write himself in to the trust as a successor trustee. And so what happened 25 years later, when my grandfather, my grandmother, and my father died, the attorney was a trustee, and it leads to an interesting outcome. So let me give you a little bit of background, an example of why I'm in this business. Well, my dad went to the hospital one day, many years ago, to take his mother off of life support. He went with her living will and presented the living. This is a tough day, no matter how you slice it, okay? The day that you go to the hospital to take your mother off of life support, that's a tough day. So dad goes to the hospital and he shows his mother's living will. And the administrator of the hospital looked at this document and said, yep, nope, you cannot use this document because it does not meet the form factor or the content requirements for the state of Oklahoma, because it was drafted by a New York lawyer, right? Go figure. All these documents, especially healthcare documents, are very specific and different state to state. So my dad was told, no, he can't use this living will to take his mother off of life support. So he went to a judge, and the judge looked at the document, perfectly drafted, other than it didn't meet the form factor of that state, but it clearly expressed her wishes not to be kept alive if she was terminal, vegetative, or comatose. But it didn't meet the state's form factor requirement, of course. So my father presented this to the judge and said, clearly it was her wish not to be kept alive. The document is clear about her wishes. It was signed and notarized and witnessed properly. And the judge looked at it and said, yeah, but it does not meet the content requirements or the form factor requirements of the state of Oklahoma. So the judge said to my dad, if you use this document to take your mother off of life support, we will try you for murder in the state of Oklahoma. Seriously, this is the truth. And so my dad took his mother out of the hospital back home with round-the-clock skilled nursing care for almost 3 years, 3 shifts a day for almost 3 years. And she lingered in a coma, in a vegetative state, essentially. And interestingly, my father and his sister were fighting over how to divide the estate upon her death. Well, it wasn't until they stopped fighting about 2.5 years later that my grandmother passed away. So they buried the hatchet, my grandmother passed away. And then my father and his sister, who really were at loggerheads, began the process of trying to settle the estate. And they argued for years about how the estate was to be divided. And of course, the attorney, if you remember, who drafted the documents, was doing quite happy with the disputes because he got to build the estate and build the trust for all of the phone calls that he took from both sides of the conversation. And it was a huge mess. And the attorney, who was trustee of my grandfather's trust, took more than a year before actually sitting down and drafting the 2-3 page document that memorialized my father's and his sister's agreement on how they were going to settle the estate. So my dad would call me frustrated and say, hey, this attorney is dragging his heels. He's really, throwing a monkey wrench into the works, delaying things. And I said, Dad, who lived in London, he needed to travel to New York and sit in the lobby of the attorney who had named himself as trustee of the trust until this attorney drafted the document. So my dad arrived in New York and every morning for a week showed up at this guy's office until he prepared the agreement that memorialized how he and his sister were going to split my grandparents' estate. So my dad went back to London for 10 days to do his laundry and, wait for the attorney to finalize the document. And then my dad died in his sleep. So nothing could be done, right? Everything changed with my dad's passing. And so that's sort of an example of how everything that could go wrong in my family circumstance did go wrong. And that's what motivated me after 2.5 years of trying to settle my father's and my grandfather's estates at the same time. I decided to start a business that would help my business today, life planning, to help as many people as possible avoid the kinds of frustrations and problems that we experience as a family and that are actually so very common in this area. And there are a lot of reasons why, and I'll explain a little later in the program. I'm going to do a presentation about estate planning that I think you'll find to be very educational and helpful. And it's about the personal estate planning around your businesses, your operating companies, your rental properties, that sort of thing, because there are many potential problems that can arise from those kinds of structures as well. Stay tuned. I think you'll find that to be a very, very interesting 20 minutes of information to provide you. So I'm going to take just a brief moment and ask you to like, share, and subscribe. Again, just take a moment, click the like button, click the subscribe button. That would really help our channel as we move forward. So, and don't forget to go ahead and text us your questions and your particular circumstances with some detail, not a ton, but a little bit of detail. And I'll do my best to address your questions and come up with a solution that you might consider, okay? Let me also say that if you choose to engage me in conversation offline through a Zoom meeting or a phone conversation, that initial meeting is never at any cost or obligation to you, okay? Know that I will always be happy to invest time understanding your circumstance, discussing it, and presenting you with some answers to your questions and hopefully some solutions to the problem by way of introduction to the right lawyer or the right attorney to take care of that matter for you. Okay, fair enough. So just a little bit about the law in general. So actually, you know what? I think I'd like to go to the presentation now, because that will give you some good background on me and my why, and then give enough information to sort of paint the picture about the law in general and where it's going and how I fit in as an advocate for people just like you, an advocate, the small person, the people law, someone who has a personal legal need, working with lawyers and all of that. And I'll explain where the value in all that is. So let's go to the first slide. Okay, so a little bit about my company and myself. We are Arizona certified legal document preparers. So I'm not a lawyer, but I'm certified by the Supreme Court of my state, the state of Arizona, to give consumers legal information, general legal information, and to provide legal document preparation services. So the big difference between the way I approach preparing a legal document and a lawyer approaches it is that, one, I don't give legal advice. I'm not a lawyer, I cannot advise, but as a certified legal document preparer, I can provide enough information, legal information, to help my clients make fully informed decisions. So instead of saying you should do this, you shouldn't do that, I'll say, well, if you do this, this is the result. If you take this approach, this is what you can expect. But other people want to wind up over here, so here's the approach they take. And if a client chooses what's behind door number 2, for example, and I know based on a lot of experience, 27 years and thousands of clients, if I know that's sort of a mistake or there might be a better way to do it, I won't say, oh, you shouldn't do that. I might ask questions. Well, what if this were to happen? What if that were to happen? And sort of redirect my client with enough information to make the right decision based on all of the information that they need. So actually, my approach is a competitive advantage because my clients know exactly what they're doing and why, as opposed to an attorney who might ask 10 or 15 questions, do the calculus in their head, prepare the documents and say to a client, okay, sign here, sign there, blah, blah, blah. Many of those clients come to me years later and say, here are our documents. We have no idea what it is that we have. Well, clients after working with us know exactly what they have and why they've done what they've done. So our solution is actually a faster, easier, more cost-effective solution. The other big difference between my approach to providing legal solutions for clients is that it's confidential. Your information and our conversations are confidential, but there's no attorney-client privilege. So just keep that in mind. Can't give advice and no attorney-client privilege, but other than that, everything's confidential and there's no limitation as to how I can inform you as to your options to help you make the best decision for yourself. Okay, great. Let's go to the next slide. So a little bit about my background and experience. My family's origin, my grandfather was in business. My father went into my grandfather's business. My grandfather got lucky. He invented something that's used around the world. And my dad continued working with the company that bought my grandfather's company back in the 50s and early 60s. Then when the patent ran out on my grandfather's invention, my father quit the company that bought my grandfather's company and moved us to Europe, where he began manufacturing this industrial filtration equipment and began building pipelines and airports, essentially, all across Europe, Africa, Asia, and the Middle East. So that's where I spent my youth from age 8 to about age 22, 26, on and off. So I spent a lot of time in Europe. My company, as a result of, forgive me, because of the family business and the problems that I described previously that happened in my own family's attempt to transfer wealth, that was the genesis, that was the why upon which I based the creation of this business back in 1994. That's 27 years, I can hardly believe it. So coming up on 10,000 clients in 34 states across the country. And we did this through strategic alliances with financial institutions, broker-dealers, financial advisors, accountants all over the country who knew us to be the good guys, right? And just a little bit about me personally, you know that I grew up as an expat, as an expatriated American citizen living in Europe. Multilingual, I speak French, Italian, and German, in case you have any family members or friends who may need some help with language. I'm also a musician. I'm a drummer and a bass player, and I race cars for fun. I actually instruct people on how to race cars safely and quickly. So that's a little bit about me, okay? Next slide, please. Let's talk about the key components around estate planning. So estate planning is preparing, putting the legal documents in place in preparation for the day that one might become incapacitated through an illness of some kind or some accident, and be unable to make fully informed decisions for yourself. So if one was incapacitated by way of dementia or some other circumstance where they can't make fully informed decisions, these wills, trusts, and powers of attorney are in place so that if that were to happen or upon one's passing, that the legal documents are in place necessary to, one, avoid probate. I don't know if any of you have ever had any experience with probate. We have a growing probate practice as well at my firm for people who do not plan in advance or in time to avoid probate. So the whole idea is that if you die owning property in your own name, like if you die owning a house in your own name, it's going through probate because this legal process is required to transfer ownership out of the name of a deceased person. We'll look at probate a little bit more in a moment. But proper estate planning lets you avoid probate, maintain control over everything, and then protect assets for future generations. Business planning is another important leg of the stool of my practice, right? We do a lot of business planning. A lot of our clients have rental properties and have operating businesses. So we create LLCs and corporations, which are owned by the trust so that they can avoid probate. So we do the formation, the maintenance of company record books for LLCs and corporations and make sure that every entity that we create and that we support is in compliance with the rules. And the rules have changed quite a bit. So I'm going to do another podcast here in coming weeks on LLCs with more than one owner, because the laws have changed all across the country regarding multiply owned LLCs and what the operating agreements can and cannot do. So this is really important. This is a huge area of concern for anyone who has a partner in the business. We also do some buy-sell agreements between partners so that if one partner were to die or become incapacitated, then there's a mechanism for the surviving partner or partners to acquire those shares in exchange for the appropriate value of those shares that go to the deceased partner's estate. Does that make sense? It's a prearranged sale and purchase agreement in the event of the death of one of the partners, which is very helpful. And then, of course, there's privacy and asset protection planning, where protecting assets is very difficult. It's very, very difficult to protect assets from your own personal liability, but there are ways to do it, and we're going to look at those in just a moment. There's also, if you set it up right, there's also the ability to create privacy and anonymity around the ownership of your businesses, but that's also a very specific process with timing and all that. In other words, you can't create LLCs and that sort of thing that are publicly known, right, that are already on public domain on the Corporation Commission's website or the Secretary of State's website, and then go back and try and hide that. We have to start with anonymity and privacy from the very beginning, so keep that in mind. And also with asset protection, you can only arrange your affairs in order to protect your assets before an action arises, because after an action has arisen, a threat has arisen, or you anticipate that a legal threat could arise, it's too late. You cannot change the structure of your assets in order to protect them, knowing that a lawsuit is coming or in the midst of a lawsuit. So timing is everything in this respect. Okay, so it looks like we have a question. Are there new regulations that will impact existing trusts? It's a great question. Thank you, Matt. The biggest one right now that everyone is talking about is the possibility of this new administration changing the rules that will do away with the step up in cost basis. In other words, that would do away with the capital gains savings provisions that are currently in law, embodied in law, and that most trusts address. So here's the thing. Under current law, if you buy a house for $100,000 and at the time of your death, it's worth $400,000, that's a $300,000 capital gain, right? Under current law, if it passes to beneficiaries through a trust or community property, you get a full step up in cost basis to the value of the property at the date of death or 6 months following the date of death. So let's say that that one passes, you get the full step up in cost basis, your heirs or beneficiaries sell your home for $400,000, there is zero capital gains tax to be paid because you get the step up in cost basis. But now they're talking about doing away with the step up in cost basis, which means that if mom and dad bought a house for 100 and when they passed it was worth 400 and you go to sell it and divide the proceeds among the beneficiaries, maybe your brothers and sisters, you'll have to pay a capital gains tax of around 40 to 45% on that $300,000 gain. That's $120,000 in tax that we would not have, that under current law we would not have to pay. So we're crossing our fingers that these big law changes that are trying to work their way through Congress right now, that it does not pass. Because if that were to happen, in fact, they're talking about making the capital gains tax due and payable upon death, even before you sell the asset. How are you going to come up with $120,000 to pay the capital gains tax on a property you haven't even sold yet? I mean, this would be the biggest disaster I can think of. So that might be one change that's coming down the pike, but that we can do nothing about. First of all, because we don't know whether the law will take effect or not. We don't know when it will take effect. So we don't know if it'll be to your benefit to sell a house, for example, now in 2021, before the law takes effect, because the law could take effect retroactively back to the 1st of January, 2021, or it could take effect as of the date of passage of the law, not just the beginning of 2022. So anyway, Matt, that was a great question. Thank you. That is a big change that's hopefully not coming down the pike, but that may very well be coming back down the pike. So let's go ahead to the next slide, if we would. So let's go back. Let's go back. Back arrow, please. Okay, here are the key concepts. The key concepts around estate planning. And forgive me, I don't have control over this PowerPoint presentation, and the PowerPoint presentation has a mind of its own. So forgive me, bear with me. Okay, so here's some key concepts around life planning. The foundation, the place that we start is by taking a holistic overview, sitting down with clients, really understanding how they feel about their money, about their children inheriting money, and a wide array of other questions and concerns and considerations. So we want to be sure that we design strategies that take the whole picture and all of the moving parts within that picture into account and addresses them properly. Now, titling assets, how your assets are titled at the time of your death, is so important and can cause vastly different outcomes. So for example, we're getting to know this concept that if your house is in the trust, it avoids probate because you've already prearranged who's going to manage the trust and who's going to receive the trust assets. So no probate is required. But the way that you own title to your property, your house, your bank accounts, et cetera, if they're stuck in your name when you die, they got to go through probate. A judge has to supervise their transfer out of your name as a deceased person into the name of the beneficiaries. So that's one thing. Then another concept that's very important to a lot of people now is this concept of protecting your assets for future generations. So what if my daughter inherits, for example, when I die, and then she gets divorced? Does my future ex-son-in-law get half of my daughter's inheritance? Most people would freak out if that were to happen, right? So we have these techniques now that have evolved very nicely, protecting assets for future generations so that unintended beneficiaries will not receive. So it goes to the child, for example, and then to their children, grandchildren, great-grandchildren. It stays in the bloodline and not to spouses unless one wanted to specifically include a spouse. So that's one thing to consider. We want to create tall walls around our assets so that we can avoid pierced veils. You know, we can avoid people piercing the veil. Have you heard of this term, piercing the corporate veil? We don't want that to happen, right? Because if they pierce the corporate veil, they can get to the assets inside the structure. We want to build those walls tall and very tough. And now with new techniques, we're really able to do that in a very important way. Distributions, who's going to get it, when and how, and why. You know, you get to control these things. Who gets it, how and when, and in the manner in which you prefer. So you have a lot of control beyond the grave to say, here's who's going to get it, what they're going to get, where it's going to wind up, either in further trust or in their name, what your why is. You know, if you're charitably inclined, or you want to be sure that your children and grandchildren are educated, you can spell those provisions out within your trust. And of course, when. You don't want your child to receive $1 million or even $100,000 when they're 18, I would imagine, because then your child's or your grandchild's big decision will be, gee, college education or a red Ferrari. Okay, we want to be able to control that. And that's why we're seeing these distribution ages starting at about 25. It used to be 21, but now it takes longer and longer for a child to get through college. We want to make sure the child gets through college, for example, and then gets a couple of years working under their belts before they receive a bucket of money. Then this whole concept of what is your intention? What do you want the outcome to look like? You know, it's your wealth and it's your family. You should not feel guilted. Well, here I am saying you shouldn't. You can feel guilted into including beneficiaries if you want, but it's your dough. And you get to distribute it however you want to. Okay, that's something that's really important. It's your money. You get to exercise your power of intention as to who gets it, how, and when. And it lets you take control, really to ensure the best possible outcomes for you and your family and your particular situations and your feelings about family and money and all of that. Here is a question saying, I'm thinking about getting a trust in place. Can I get grandfathered in with a step up in cost basis and capital gains with my trust in the event the new regulations take effect? You know what, that's a great question. And in the past, the concept of grandfathering was pretty normal. But now with you know, our fiscal circumstances and situation as a country, they want their money now. And so I would think that probably the grandfathering thing, no one knows. I don't know if there is a grandfathering provision in the new body of proposed law, but I doubt it. I think that they're going to want, you know, they may make it retroactive back to the first of the year, and too bad, so sad, you know. That's just the way it's going to be. So I would bet, if I was a betting man, that no, it won't become grandfathered or what, because this law will take effect retroactively to a date prior to its passing. That's my guess. Okay. May we have the next slide in the presentation, please? And we'll address this next question here in a moment. So why do people plan? Why would you consider do this type of planning? Well, to provide for the people that you love and that you care about, to eliminate the costs and delays of probate. Let's talk about that a little bit. The average duration of probate is 15 months and is of indeterminate expense in many states. In other words, you cannot know going into the probate process what it will cost you. There are a few states like California that are very clear in the law about what probate will cost you. You know, 8% of the first 100,000, 6% of the second 100,000, 4% of the third 100,000, and then 2% of everything over $300,000. So you can pencil it out in advance. This is what probate's going to cost me. But in states like Arizona, many other states, it's whatever's reasonable and customary. That's how much you're going to pay the lawyer. So to give you an example, my dad's estate in Arizona was probated. His trust was probated in Arizona because he left one house out of his trust. This was before I got into the business, okay? Because I would have made sure his house was in the trust, believe me. But his probate took 2.5 years and cost $60,000 to complete. I mean, outrageous, right? Because one house left out of the trust. So probate, pretty much everybody knows or will know soon that you want to avoid probate pretty much at any cost. Proper planning allows you to enhance security and privacy around your estate, your assets, and your affairs. It can minimize gift and estate taxes. Okay, so this is sort of an old slide. Gift taxes right now, I'm sorry, not gift taxes, but estate taxes don't apply for couples until they've accumulated $23.4 million. Okay, so most of us, or half of that, if it's $11.7 million, if you're an individual, most of us don't have that kind of money and don't really have to do this kind of planning because of estate taxes. But it's something to keep in mind. I do have many clients in the $50 and up $1 million range that very much have to worry about estate taxes. And if you do have a larger estate and want to talk about ways of mitigating or eliminating estate taxes, we can have that conversation, okay? People do this kind of planning to protect assets for future generations. So this is really important. If your trust is properly configured and properly drafted, it will protect the inheritance that your children received, they receive one day, protects it from their creditors, judgments, lawsuits, and divorces. So if you set it up properly, and I'll talk more about this in a minute, if it's set up properly, it's outside of the reach of your children's and grandchildren's creditors. They could lose everything else that they own, but they can't lose what they inherit from you. And then one big reason to do this kind of planning is for peace of mind. I don't know how many of you who have not done planning or who know that you've got to make updates and changes to your current plan. It's in the back of our minds. We're thinking, oh, gee, gosh, I'm getting on a bus or a plane or a boat, and I haven't updated my documents. It's this nagging concern. I have clients who tell me they've been thinking about doing this type of planning for 30 years, 40 years, but haven't gotten it done. So we'll talk a little bit more about all of that in a bit. So another question's popped up. Are there other options to consider for not getting taxed on capital gains? Well, you know, life insurance. So right now, actually, all bets are off on capital gains. I can't tell you of any strategy that's coming up other than these very complex strategies of sales to grantor trusts and all kinds of other, you know, very complicated and expensive solutions that if you're in that 5, 10, 20, $50 million range and up, makes sense. But for everyday people like us, it's unlikely that there's much that we can do to avoid or mitigate these kinds of capital gains taxes should that law pass, and I'm crossing my fingers that it won't. Okay, let's pop back to the presentation. Thank you. Why more people don't do this kind of planning? Well, first of all, it's morbid. You know, it deals with death and disability, and we're human. We don't want to think about the day that we're going to die or the day that we wind up in long-term care. So that's one big impediment. It's personally invasive. You know, think about it. To do this kind of estate planning, you've got to spill the beans to a stranger. You sit down with a lawyer and they learn everything there is to know about you, your money, how you feel about kids, how you feel about life in general. So a lot of people just are too private or feel so private that they don't want to do this kind of planning. It's time consuming, it's complicated, and it's expensive. That's the perception. And generally speaking, people don't do this kind of planning because of a general lack of knowledge and understanding around how easy and straightforward and cost-effective proper planning can be. So that's where we come in to help with all of that. Next slide, please. Okay, so here's some problems with planning. The truth is that legal expertise in the area of tax and estate planning is very hard to find. The American Bar Association will tell you, and if you do a search on martindale.com, which is a database of all 1.5 million attorneys in this country, of all 1.5 million attorneys in this country, only 50,000 claim any competence in wills and trusts at all. That's 3%. But many of these attorneys who claim some competence in wills and trusts, they practice in 8 or 10 other areas, right, of the law. So they don't focus their practice exclusively or the vast majority of their practice on tax and estate planning. So when you get down into that more rarefied area, maybe 1% of attorneys know what they're doing in this arena. But the other 97 or 99% of attorneys are not competent in this area of the law. You have to really beware because they have a license to practice law, which means they have a license to practice on you. And you don't want an attorney who doesn't know what they're doing practicing on you and your family, okay? Because the outcomes often are not great. I've reviewed hundreds and hundreds and hundreds of trusts in my lifetime, in my career, and I'm shocked still to this day at how much bad work is out there. So it really pays to find someone who knows what they're doing. But the question is, if 97% of attorneys can't look at a trust and tell you what makes it a good trust or a bad trust, how can we as consumers possibly know? So if ever there was a buyer beware segment of the marketplace, it's in estate planning. Now, if you can find expertise from a lawyer, it's going to cost you a lot of money. $3,000 is actually probably a little low nowadays because these prices are going up significantly. You're probably looking at $4,500 to $5,000 and up for a competent attorney to do a comprehensive estate plan for you. So what are the options? Well, as a certified legal document preparer who's focused for 27 years on estate planning, you might consider Life Planning Inc. as an option. So let's go ahead and flip the page, if you would. Thank you. So there are several different strategies for transferring your estate upon your death. The most popular plan for transferring your estate upon your death is no plan at all, which means that roughly 60 to 70% of the population don't have a will, don't have any documents in place. Now, most people don't know that a will requires probating. This is news to a lot of people because, hey, I put my wishes in writing in a will. Why does it have to go through probate? We'll look at that in a minute. But the fact is that with or without a will, some form of probate is usually required. A will is subject to approval by the probate court, approval and supervision by the probate court. The probate process itself is designed to hear contests against your estate and claims against your estate. So anyone can show up at my probate, for example, and say, hey, I'm here to collect that $10,000 that Warner promised me 20 years ago when I helped him out of a jam. Well, that's a claim, right? The judge has to determine if it's a rightful claim or not, and whether to grant that claim or not, which can stretch out the process, make it more expensive and more time consuming for the family. So a will can be a problem for sure. We can avoid probate through beneficiary designations. For example, the use of POD, pay on death, or TOD, transfer on death designations for bank accounts, brokerage accounts, life insurance, IRAs, even residences, even real estate in certain states. More and more states have what we refer to as a beneficiary deed, which names the beneficiaries in the deed, in the title to the property. The problem there is that the way the beneficiaries receive it is usually not made clear in a beneficiary deed. In other words, your three children, do they inherit this property upon your death through a beneficiary deed as tenants in common, as joint tenants with rights of survivorship? I mean, those outcomes are very, very different, and they are normally not addressed in a beneficiary deed. And then joint tenancy. This is a very common concept on how to avoid probate. And it works well when you have joint tenants with rights of survivorship. At the first death, the survivor inherits by operation of law automatically. But what happens when the second joint tenant, the surviving joint tenant, dies? When the second joint tenant dies, if they haven't created a trust or a beneficiary deed, some way to get that deed out of their name, it's going through probate. Another issue with joint tenancy is, let's say that mom has three daughters. One lives locally, one's on the West Coast, one's on the East Coast. So she puts her local daughter on the title, on the deed to her property and her bank accounts, so that if something happens, we'll avoid probate. Great. Well, mom dies, and that one daughter inherits by operation of law. Everything's in her name. And technically, she is under zero obligation to share that money, to share that inheritance with her sisters, because by operation of law, it named her as the sole beneficiary, as a joint tenant. So there's some unintended consequences of joint tenancy. One more, because this is a good one. Let's say the daughter who's on accounts in the house as joint tenants, let's say she gets into a car accident and she gets sued, and they do a search for all of the daughter's assets, including the house she's on deed and title to with her mom, and the bank accounts that she's on title to with the bank. Now, mom and her house and her bank accounts become party to the lawsuit against the daughter who had an accident and who's being sued. I mean, wow. If more people knew about this, they'd be very careful about relying on joint tenancy in order to avoid probate. Okay, thank you, Toby. One more, if you would. So here's one definition of a will, a definition that I really, really love. A will is a one-way ticket to probate court. It's a lawsuit that you file against yourself using your own money for the benefit of your creditors or for the people who claim that you owe them money. Remember, somebody can show up at your probate and say, oh yeah, you promised me, he or she promised me 10 grand all these years ago, I'm here to collect. That can be a problem. So probate is a problem, and it's one that can be easily avoided with proper planning. Next, please. So a little bit about probate. So this is we'll just stay on this one for a second. This is the probate. It's about 2/3 of the probate process, okay? all of the things that the executor of your will has to do in order to complete the probate process. We could not get all of the stages and steps required by probate onto one slide. So this is about 2/3 of it. This is why you walk into a court and try to start probate yourself, they'll discourage you. They'll say, you know what, you really shouldn't try this at home. You really should get an attorney or someone who's competent at administering a probate, helping to get probate started and completed timely in an efficient manner. So this is why over the years we've developed a very thriving, vibrant probate practice, unfortunately for the people who we can't get to in time to do the planning necessary to avoid probate. Let's move forward. One more slide forward, please, if you would. So you probably have heard the term revocable trust and irrevocable trust. And here are the differences. A revocable trust is the cornerstone, the foundation of any good plan. You create the living trust and we title the house into the trust. We title the bank accounts into the trust. We name the trust as the beneficiary of life insurance, of qualified plans, of IRAs, and that sort of thing. All roads lead to the trust during your lifetime. And this helps to avoid probate and protect assets for beneficiaries. But revocable trusts, while you're alive, do not protect your assets. Because the trust is revocable, you can blow it up, take everything out of the trust, back into your own name at any time. You can put stuff in, take it out, put it in, take it out. You as an individual or you as a couple and you as trustee or trustees of your trust are the same person under the law. So there is no asset protection. When you transfer something from your name into your name as trustee, you haven't done anything really to protect your assets. But the good news is that revocable trusts always become irrevocable upon death. So at the first death, it becomes partially irrevocable. At the second death, it becomes completely irrevocable. And irrevocable trust is the fortress that sits on top of the cornerstone of a foundation, which is the revocable trust. So upon death, the trust becomes irrevocable and it protects assets. So let me take a step back. One can create an irrevocable trust during lifetime. So life insurance trust, irrevocable life insurance trust, for example. You create this irrevocable trust, you put life insurance into it, you fund it with money, all that is gone. You can no longer benefit from it by one penny. If you put $1 million into an irrevocable trust for your children, for example, it's good for them, they can use it, but you'll never see a penny of that money. And most of us aren't in a position to give money away yet, right? But when we pass, these trusts become irrevocable and do protect assets for future generations. I'm not going to talk about idiots and things like that right now. If you have questions around asset protection planning, just reach out, contact us. We'll schedule some time and we'll talk about that offline. Okay, let's go to the next slide, please. So let's talk about asset protection for business owners. If you own a business, we need to understand first your current business structure. Is it an LLC? Is it a corporation or a partnership? Is it owned with just you as the shareholder or the member, or do you have multiple owners and shareholders? So we understand the current business structure first. We look at the pros and cons of these commonly used structures because there are many actually in terms of taxation, annual reporting, annual fees, these kinds of things. So this is all part of what we talk about with our business clients or our investment property, our rental property owner clients, so that they're sure to be making the right selection. And we always include their accountant in this process too, because the legal side and the accounting side of the same question are often at odds. You can protect the assets, but you complicate the tax reporting and the tax requirements a little bit. So this is sort of the trade-off, and we always want to include your tax person in that conversation. We want to make sure that whatever entity you create, an LLC or a corporation, achieves and maintains compliance with the rules around administering the LLC or the corporation properly, and we'll talk about that a little bit more. We want to make sure that the shares or the ownership of the LLC or the corporation are titled properly as well. Just like all of your other property, you don't want to own stuff in your own name, right? You want everything that you own to be owned by the trust with you as trustees, with you as managers. So you control what the trust owns. So you control and own through the trust the LLC, and you can also be the manager of the LLC. So you're the day-to-day operator or manager of the company, but the trust is the member, the owner, so that it can avoid probate. And then we look at different asset protection strategies and techniques. There are some great options, especially for married couples, that they can deploy to really protect assets, both during their lifetimes and upon death. So the key to success is the structure and then complying with the rules around that structure, like updating, making sure everything's kept up to date and compliant. Okay, any questions, go ahead and shoot us a text or give us a call. You'll see the, the contact us information. Just reach out and check in with us. So limited liability companies, an LLC can be created for any legal business, okay? You can't create an LLC or any other kind of business structure for an illegal business, the law says, but you can create an LLC for any lawful business. A PLLC, a professional limited liability company, is for professionals like doctors, accountants, lawyers. You can create a PLLC. The difference between a PLLC and an LLC is that only a professionally licensed and appropriately licensed professional can own and operate a PLLC or a PC, a professional corporation. There are some real estate practices and other medical practices and professional practices that are just LLCs that removes that compliance requirement that a PLLC otherwise would require. So limited liability provides great internal liability protection. In other words, if you have a rental property and it's in your LLC and someone slips and falls on your property, your personal liability is limited to what's in that LLC. They can't jump over the wall and get to everything else that you own. That's if, though, and it's a big if, that's if the LLC is properly documented and properly administered. We'll talk about that in a little bit. The law says that every action that you take on behalf of the LLC must be by written consent. Otherwise, it makes you personally liable. So it's so important to keep up with meeting minutes and other written instruments that give you permission to have done what you're doing on behalf of the LLC or the corporation. It's pretty easy to pierce the corporate veil. You may have heard this term, piercing the corporate veil, which you do not want to happen, but does often happen in the event of a lawsuit or an audit by the IRS. Because in an audit or a lawsuit by the IRS, an audit by the IRS or a lawsuit, the first thing they do is ask to see your company record books, your operating agreement, your organizational meeting minutes, your stock ledger, your seal, your everything. And if you can't present a pristine set of company records, then it makes it easy to pierce that corporate veil and say, oh, you've been operating this LLC not as a separate entity, but as an alter ego, the same as if it was you. So they pierce that corporate veil, you lose all of the protections that the LLC can provide you, and it makes you personally liable. Now, we estimate that 95% of existing LLCs will not protect their owners because they're not properly documented. But an LLC, even if it's properly administered and documented, it provides good internal liability protection. It provides zero external liability protection. Let's look at the next slide. So go back to, if you would, that one right there. Perfect. So this is the traditional, typical probate avoidance structure where you have the living trust that owns your operating company, maybe your rental properties, limited partnerships, investments, anything else that you may own in an LLC or a corporation. The living trust owns, it's the member of those different LLCs. And the LLCs underneath, if properly documented, will provide great internal liability protection for those rental properties, for the operating company. But if one were to, let's say, injure someone seriously in a car accident and become sued, they would come in through the living trust, because remember, you as an individual and you as trustee of your trust are one and the same person. If they're suing you, they're suing the revocable living trust as well, and they can get to everything that's in the trust and everything that's below the trust, right? They can take your operating company, they can take your rental properties. That's the extent of your liability in the event of external liability, like that car crash that happens. Let's go ahead and flip the page. Now we're going to look at an asset protective structure where you have a multi-member holding company that has two members, two owners. One is the revocable living trust, and the second owner is an irrevocable trust of some kind. So let's say 90% owned by your trust and 10% owned by this irrevocable trust. Remember, in irrevocable trust, you're giving 10% of everything that you own to this entity and to the beneficiaries of the entity. So your children, for example, might be the beneficiaries of this 10% owner of the irrevocable trust. So that often works well. People with going businesses, going concerns want to find a way to distribute some of that income to a lower tax rate taxpayer like their children. So what's interesting about this is that that multi-member holding company serves as a firewall, essentially, between external liability, that car crash, where they go to sue the owner, sue the person who was driving the car, causing the accident. And now they see that their trust owns 90%, but there's a second owner of the holding company that owns everything that the client owns. And the law says that it's harder to get a judgment or a charging order against an entity that has more than one owner, because they wouldn't just be harming the person driving the car, the person who owns the living trust. They'd also be harming the irrevocable trust and the beneficiaries of the irrevocable trust. So this is sort of the most basic form of dividing and conquering to provide lifetime asset protection. So just to give you an idea, there is no guarantee around asset protection. There's no guarantee that you're going to actually protect your assets, but you can try to build up these structures that make it more difficult. So the question is, if my documentation for my LLC is in place, does this mean that piercing the corporate veil is no longer possible or likely to happen? No, honestly, there is no pure guarantee of asset protection. Anyone can sue anyone else for any reason at any time. And, you know, what you're doing with the LLC is you're making a best effort to build the wall up in a way, and to structure the wall and administer the wall in a way that will survive attacks. Okay, but there is no actual guarantee ever that someone will not be successful in piercing the corporate veil. But at least having your structure in place, they're going to look at this and go, okay, well, all of this has been done properly. And we would have to spend a lot of time and money to find the kinks in the armor. And so it may encourage the person suing one to just move on and try to find another way, you know, maybe tapping your umbrella policy for money, those kinds of things. So no, there's never any guarantee when it comes to asset protection planning, but at least we create these structures in order to increase your chances as greatly as possible to create a veil that's difficult to pierce. Can't say impossible. So here are the essentials. I'm going to wrap this up now. Here are the essentials around life planning. One, we always begin with the end in mind. Who, you know, do your children get along? Spouses, grandchildren? So we have to think about who's going to be receiving and how they all interact. What kinds of assets are you protecting and distributing? So a house is different than distributing a business, very different. Where are the assets located? Assets may be located all around the country. It's not uncommon for people to have vacation homes in other states. So we need to think about this too, because if you die owning property in more than one state and you haven't done this kind of planning, now you have to do a probate in every state in which you own property, right? So the trust really makes a lot of sense, especially if you own property in more than one state. You know, what ages do you want your children to attend? Oh, where are the assets located? Multiple institutions, multiple states, different banks, different brokerage firms. The question of when, what ages do you want your children or grandchildren to attain before they actually get control over the money? That's a big deal. If you say too early, like 18, maybe they make that choice between a red Ferrari and a college education. But if you keep it in further trust to say 25 or 30 or later even, then the trustee can manage and help to control the use of that money for the beneficiary by paying for their education, their health care, and those kinds of things, without just giving the purse directly to the child before they're able to really ready to manage it and handle it. How will the assets pass? How will businesses be managed? Okay, who's going to get your business when you die? That's another big problem that we can solve through proper planning. How will assets pass, either outright and free of trust into the name of your children, which means that if they get divorced or if they have an accident and get sued, if that inheritance is in their name, it could be taken from them. But if their inheritance from you, they receive it in an irrevocable trust where the money doesn't come out of a perfectly good irrevocable trust, which does a great job of protecting assets, then then they can protect it from their creditors, judgments, lawsuits, and divorces. But if they inherit it in their own name, it can be taken from them. So these are things to think about. And then what's your why? What motivates you? Is it charitable? Is it education? How do you envision this money, this inheritance, adding to the success of your children and grandchildren rather than taking away the chances of them being successful? I mean, I don't know about you, but some of the most successful people I've ever met have come from the most modest and difficult backgrounds. Some of the most spoiled and least productive people, and this is not true, don't take this the wrong way, but I've seen many people who've never worked a day in their life because they've inherited so much money they don't have to. And so there's a fine line between, and you can manage the expectation around how you want your children to use their inheritance in a well-drafted living trust. And then, of course, laws change, as we know, so it's important to have periodic reviews of your documents so that we can make sure that they're up to date all the time and that they currently accurately reflect your wishes at the time, okay? So the process, you'd schedule a conversation with us. It's always any conversation, any consultation that you arrange or schedule with our company is always at no cost and no obligation. So it's just a fact-finding, information gathering meeting, if you will, for both you and for us. And if you decide to move forward, that's great. And if you decide to take that information and use it any way you want, that's okay too. We'll review all of your existing documents again at no charge, no obligation. So if you want to know how your trust is configured and if it has a chance of succeeding, then shoot it over to us. And go ahead and go to the last page, if you will. This is our contact information. Life Planning Inc. I'm the CEO. Our address is 8283 North Hayden Road, Suite 200 in Scottsdale, Arizona. But again, we have clients all over the country. So no matter where you may be, when you hear this podcast, just know that we can provide you with information, understand your circumstances, give you some ideas with respect to potential solutions, and then connect you with the right attorney. Getting back to Legal Concierge, the whole purpose of this podcast is to help educate clients, provide them with legal information and solutions, answers to their questions, first of all, and then solutions to their legal needs by matching their legal needs and their unique circumstances with the right attorney who knows what they're doing in that area of the law. So again, please like, share, and subscribe. I would be very grateful to you for doing that because it helps our channel. This is the first podcast of what will be many. Appreciate your tagging along and participating in it with us. You may actually download this or view it on YouTube or Facebook or any number of other platforms where we'll be distributing at any time in the future. But I think all the information in this presentation in this last hour is current, at least as of today. So thank you very much. I appreciate your coming down this path with us. Feel free to call, contact us. Delighted to chat with you and meet you and help any way we can. Okay, thanks. See you next time.
Thank you for joining the Legal Concierge podcast hosted by Warner Lewis. Please subscribe and leave a comment or question regarding your own legal situation, or ideas for future shows. Share this podcast with your family and friends so they can find answers regarding legal situations and solutions, too. Check the show notes for links and resources, and please come back again next week.